Neutral citation number, 2017, EWHC 433, QB. In the High Court of Justice Queen's Bench Division. Before, Mr. Justice Warby. Between, Jack Monroe claimant, and Katie Hopkins defendant. Date, the 10th of March 2017. Mr. Justice Warby, this is the trial of a libel claim arising from two tweets sent by the defendant, Katie Hopkins, about the claimant, Jack Monroe, on the 18th of May 2015. The defendant is a journalist who writes for the Mail Online. The claimant is a food blogger and writer. The claimant, assigned female gender at birth, now identifies as non-binary transgender. But by agreement, I shall call her Ms. Monroe and use feminine pronouns. Ms. Monroe's complaint is that the tweets accused her of vandalizing a war memorial and desecrating the memory of those who fought for her freedom, or of approving or condoning such behavior. Ms. Hopkins does not suggest that Ms. Monroe did behave in either of these ways. Her answer to the claim is that her tweets do not bear the meanings complained of, are not defamatory of Ms. Monroe according to common law principles, and, or in any event, are not defamatory because it has not been shown that they caused serious harm to Ms. Monroe's reputation, as required by S1 of the Defamation Act 2013. The issues as to liability are, therefore, 1. What meanings were borne by the tweets, 2. Whether those meanings had a defamatory tendency, and if so, 3. Whether it has been proved that the serious harm requirement is met. The trial has been short. The only oral evidence has been that of Ms. Monroe, who has been cross-examined for the best part of a day. Mrs. Hopkins has not given evidence. She relies on two witness statements made by her solicitor, Ms. Harris, analyzing a body of Twitter records. Those statements have been admitted into evidence by agreement, without cross-examination, though without accepting the accuracy of the analysis. Ms. Hopkins also relies on facts and documents that have been put before the court by agreement. The claimant, Ms. Monroe, is 28 years old. She comes from a family with military connections. Her father was in the British Army for 7 years, being decorated for active service in the Falklands. He spent the next 30 years in the fire service. One of her 3 brothers is a flying officer in the RAF. She herself applied to join the RAF at the same time as her brother but was not accepted. She joined the fire service, serving for some 4 years between 2007 and 2011. She left the service due to the difficulties of combining it with motherhood, and spent 18 months on benefits. In 2012 she began blogging, on political topics. She is on the left. In due course she became a food blogger and cooking journalist, gaining a cookbook deal in around May 2013 and joining The Guardian in October 2013 writing recipe and cookery columns as well as more general political commentary. She has played a role in mainstream politics, speaking at Parliament on the debate about food banks, contributing to a report by Frank Field MP and speaking at party conferences. Ms. Monroe joined Twitter when in the fire service. From early 2012 her Twitter handle was at Ms. Jack Monroe. Although she has changed it since, that was her handle at the times relevant to this case, when she had around 70 to 75,000 followers. At that time, she was on Twitter every spare waking moment, as she puts it. She accepts the defendant's estimate that she had tweeted around 20,000 times. She also accepts the defendant's pleaded characterization of her as an outspoken political activist who has been highly critical of the Conservative Party and its policies, particularly its pursuit of austerity measures, whilst in government. She is, I find, often forthright in the way she expresses herself, and has quite often used profanities and other strong language on Twitter. This is a description that those who know her from Twitter would recognize, though they might use different words. The defendant, Ms. Hopkins' Twitter handle is at KT Hopkins. Her current Twitter profile describes her as a columnist at Mail Online, LBC radio host, CBB runner-up. In May 2015 her profile identified her as a columnist for The Sun. For the purposes of this case, she describes herself as confrontational, outspoken, forthright, often outrageous and frequently flippant in her journalism and social media activity, and very well known as such. With the exception of the words frequently flippant, this description was accepted by Ms. Monroe under cross-examination. On the basis of the evidence in this case, I would agree with it. I would agree that Ms. Hopkins is sometimes flippant. Ms. Hopkins has sometimes been described in the print media as rent-a-gob, but this is not a term that Ms. Monroe had heard used about her. She said, "I tend to move in circles of cookery and politics rather than outrage and vitriol." The evidence shows that Ms. Hopkins is often acerbic, and known to be so. Mr. Price has not pressed the point he put to the claimant, that rent-a-gob is how everyone sees Ms. Hopkins. The general picture is not, however, significantly controversial. Nor is it controversial that her politics are of the right. When Ms. Hopkins joined Twitter is not disclosed in the evidence, but the evidence is that her homepage is very popular, with over 5.7 million visits in each of April and May 2015. It is an agreed fact at the relevant times she had about 570,000 followers, and had tweeted about 44,000 times. The evidence makes clear that she was tweeting frequently. By way of example, the Twitter analytics for her account show that on the 18th of May 2015 she sent her first tweet at 7:07 a.m., and the second tweet complained of, sent at 21:47, was her 30th of the day. Ms. Penny, another character who features quite prominently in this case, though not as a witness, is another journalist, Laurie Penny, a columnist for the New Statesman magazine. Her Twitter handle at the relevant time was at Penny Red. As this summary suggests, she is of the political left. In March 2016 she had about 128,000 followers. A reasonable estimate of her followers in May 2015 is 100,000. The history in short: on Thursday the 7th of May 2015 there was a general election. On the 8th of May the Conservative Party formed a government. On Saturday the 9th of May, there was an anti-austerity demonstration in London. It turned violent, and the memorial to the women of World War II in Whitehall was vandalised. The words "fuck Tory scum" were spray-painted on it. This act was widely reported in the news and elsewhere, with photographs of those words sprayed on the plinth. The act caused public outrage and widespread public condemnation. It is Ms. Monroe's unchallenged evidence, which I accept, that she was aware of the graffiti via the news media and, despite her general support for anti-austerity groups, as a proud member of a military family and a feminist, she flatly opposed, and was sickened by it. She agrees with an official statement issued from Downing Street at the time that this was a despicable display of disrespect for those who fought and died for their country. On the evening of the 9th of May 2015 there was Twitter activity relevant to this claim. 1. At 8 p.m., a Twitter user with the handle @little_G2 tweeted at Penny Red, sending a photograph of the vandalized memorial and asking at Penny Red to comment on it. 2. At 8:01 p.m. at Penny Red commented, at @little_G2 at Criado Perez, "Actually, I think that's fine," and many of those women would have agreed. Sadly they were not able to vote. This comment was RT'd 25 times. 3. At 8:04 p.m. at Penny Red tweeted a photograph of the vandalized war memorial with the accompanying words, "I don't have a problem with this. The bravery of past generations does not oblige us to be cowed today." This tweet generated a deal of comment, much of it adverse. This tweet was RT'd 356 times, liked 226 times and replied to in 618 tweets. 4. At 9:40 p.m. Ms. Hopkins tweeted a photograph of the vandalized war memorial, and a link to at Penny Red's tweet of 8:04 p.m. with these observations, at Penny Red thinks this is okay. Burn her passport, bulk buy her lube and make her a woman of ISIS. This was RT'd 135 times. 5. At 10:33 p.m. Ms. Hopkins tweeted again, with a photograph of the war memorial and a hyperlink to at Penny Red's homepage, "If at Penny Red was my daughter, she would be out tonight scrubbing this clean with her tongue for what she has said." This was RT'd 529 times. On Sunday the 10th of May 2015 the mainstream news media reported on Ms. Penny's tweets, and Ms. Hopkins' denunciation of Ms. Penny. 1. Metro reported under the headline "Katie Hopkins, woman who agreed with memorial graffiti should be bought lube and made woman of ISIS." 2. The Daily Star published a piece headed, Send her to be raped by ISIS, Gobby Hopkins horror tweet to left-wing writer. 3. The Independent published an article headed Katie Hopkins trounces Laurie Penny in battle of offensiveness over anti-Tory graffiti, suggests she should be made a woman of ISIS. On Monday the 11th of May 2015 the Mail Online published a piece about Ms. Penny's "I don't have a problem" tweet. The article was headed "Sneers and Bile of Hate-Filled Left, Protesters Desecrate Memorial to Those Willing to Die in the Fight to Protect Democracy." It gave a slightly different version of the tweet, which included not only the sentence beginning "I don't have a problem," but also the words, "What's disgusting is that some people are more worried about a war memorial than the destruction of the welfare state." This was a compression of two separate tweets by Ms. Penny. The article cited the composite tweet as evidence that Ms. Penny was a member of the leftist commentariat who had been lining up to spout hatred and ally themselves to the rioters at the anti-austerity march. On the 18th of May 2015, at 7:20 p.m. Ms. Hopkins posted the first tweet of which Ms. Monroe complains, the first tweet. It was in these words, at MS Jack Monroe scrawled on any memorials recently? Vandalized the memory of those who fought for your freedom. Grandma got any more medals? 2. At 7:33 p.m. Ms. Monroe tweeted in these terms, I have never scrawled on a memorial. Brother in the RAF. Dad was a para in the Falklands. You're a piece of shit. With a screenshot to the first tweet. 3. Ms. Monroe tweeted again at 7:36 p.m. I'm asking you nicely to please delete this lie, Katie, and if I have to ask again it will be through my lawyer. With a link to the first tweet. 4. At 8:14 p.m. Ms. Monroe tweeted again, this time using Ms. Hopkins' Twitter handle, Dear at KT Hopkins, public apology plus £5,000 to migrant rescue and I won't sue. It'll be cheaper for you and V. Satisfying for me. 5. At some point between the posting of that tweet and 9:47 p.m., the first tweet was deleted by Ms. Hopkins. 6. At 9:47 p.m. Ms. Hopkins posted the second tweet of which Ms. Monroe complains, the second tweet. It was in these terms, can someone explain to me, in 10 words or less, the difference between irritant at Penny Red and social anthrax at Jack Monroe? 7. At some point that evening, I infer about this time, Ms. Hopkins blocked Ms. Monroe. That prevented Ms. Monroe from communicating with her via Twitter. 8. Later on the 18th of May 2015 the claimant published the following on Twitter, BA_DA_boom. It lies. It smears. It's wrong. It panics. It blocks. It's at KT Hopkins everyone. With 6 pictures of a chicken. 9. At 22:30 on the 18th of May 2015 the claimant published the following on Twitter, Gin O'Clock. Cheers. God, isn't it good sweet justice when a poisonous bully gets shown up for what it is and runs away. 18. 19. 20. On the 19th of May 2015 there was extensive press coverage of the Twitter exchanges between Ms. Monroe and Ms. Hopkins the previous evening. Articles were published in the Huffington Post, the Mirror, the Independent, Belfast Telegraph, the Metro, Kitch Mix, Zello Street, Gay Star News, and Diva Mag. The overall theme of these articles is encapsulated in the Mirror's headline, Jack Monroe and Katie Hopkins in huge spat. A letter of complaint was sent promptly by Ms. Monroe's solicitors, Seddons. On the 21st of May 2015 they wrote to Ms. Hopkins' care of STH Management. They said, among other things, the words were highly defamatory of Ms. Monroe and have caused a huge amount of stress and trouble. Despite those tweets being made by Ms. Penny, it is clear that you thought they had been made by Ms. Monroe. Quite clearly your followers, who number over 500,000, shared the confusion that you promoted and consequently Ms. Monroe was subjected to a torrent of abusive and vile comment. When it was pointed out by you to Ms. Monroe that you had made a mistake you decided not to take action but instead aggravated the position by tweeting, at 9:47 p.m., the letter requested a correction and apology, an undertaking not to repeat this or similar tweets about Ms. Monroe, payment of a substantial donation to a charity of Ms. Monroe's choice, and payment of legal costs. The form of correction and apology Ms. Monroe wanted was spelled out, a tweet to be sent at a date and time to be agreed. I was confused about identity. I got it wrong. At MS Jack Monroe, I'm sorry. I have made a substantial donation to charity at her request. There was no reply to that letter. But 12 days later, on Tuesday the 2nd of June 2015, at 6:58 a.m. Ms. Hopkins tweeted at MS Jack Monroe, "I was confused about identity. I got it wrong." She did nothing else, until after Seddon's wrote again on the 4th of August 2015. Seddon's letter noted that there had been no reply to theirs of the 21st of May. It said that all previous offers were withdrawn and that proceedings were being prepared and would be served on Ms. Hopkins personally unless she nominated solicitors. This evidently prompted Ms. Hopkins to instruct Kingsley Napley, who wrote on the 14th of August 2015, "We are taking urgent instructions from our client and will be in a position to respond substantively to your correspondence in the early part of next week. In the meantime, it would be premature to issue proceedings, particularly in circumstances where the tweet has been removed months ago, and a retraction made. If it assists, we can also reassure your client that there is no possibility that our client will repeat the words complained of or similar in the future. In such circumstances, it would seem sensible to pause before issuing a claim, particularly where we have not explored with you the quantification of any serious harm or losses that your client claims to have settled." Following further correspondence largely devoted to exploring the issue of serious harm, these proceedings were issued in December 2015. The defense raised the three issues identified at the outset of this judgment. It also averred that Ms. Monroe had herself extensively publicized the tweets containing the statements complained of, the circumstances of the tweets, her denials in relation to the tweets, that the defendant had been mistaken in mentioning her in the first tweet, and her contempt for the defendant's conduct and the defendant generally. The defense denied Ms. Monroe's claim to have suffered substantial upset and distress, pointing to the obvious pleasure taken by her in threatening these proceedings, and to her activity on Twitter in relation to the matters complained of. Legal principles: the core principles of defamation law according to which this claim must be decided are not in dispute. For the purposes of this case they can be summarized in this way. 1. Libel consists of the publication by the defendant to one or more third parties of a statement about the claimant which has a tendency to defame the claimant, and causes or is likely to cause serious harm to the claimant's reputation. 2. Whether a statement about the claimant has a defamatory tendency is determined according to common law principles. But a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the claimant's reputation. S1 Defamation Act 2013. This provision, the serious harm requirement, means that it is not enough to prove that a statement had a defamatory tendency. A claimant must prove as a matter of fact that their reputation suffered, or is likely to suffer, serious harm as a result of the publication complained of. It is common ground that the right starting point in this case is to decide the meanings of the tweets. After that, it is necessary to determine whether the meanings arrived at have a defamatory tendency, according to the common law tests. If they do, the next step is to make findings about the extent of publication. Finally, I must consider whether the serious harm requirement is satisfied. What did the tweets mean? Ms. Monroe's case is that the first tweet bore one or other of two natural and ordinary meanings, either, 1. That she had vandalized a war memorial and had thereby desecrated the memory of those who fought for her freedom and had committed a criminal act, or alternatively, 2. That she condoned or approved of the criminal vandalization of a war memorial and the consequent desecration of the memory of those who fought for her freedom. The argument for Ms. Hopkins is that the first tweet did not suggest or imply that Ms. Monroe had herself vandalized any memorial. Read in their full and proper context, they mean no more than that Ms. Monroe was supportive, politically, of those who had painted the slogan onto the monument. Ms. Monroe complains that the second tweet bore an innuendo meaning that she approved or condoned the criminal vandalization and desecration of the Women's War Memorial in Whitehall during an anti-government protest. The innuendo facts relied on are, the vandalization of the war memorial, the outrage it caused, Penny Red's "I don't have a problem" tweet, the wide reporting and comment on that tweet, the two tweets published by Ms. Hopkins, condemning at Penny Red's view, and the fact that the second tweet referred to at Penny Red's view. Those facts are all agreed, though it remains to consider whether everybody who read the second tweet was aware of them. 28. The argument for Ms. Hopkins is that the second tweet did not bear the meaning complained of. It would have been understood, by the ordinary reader, as no more than a petulant acknowledgement by her that she had mistakenly identified Ms. Monroe instead of Miss Penny. Alternatively, it is argued that the second tweet bore the same meaning as the first tweet, that Ms. Monroe was supportive, politically, of those who had painted the slogan onto the monument. Discussion and conclusions. It is important to separate the question of what message a reader would take from the tweets from the separate question of what response the reader would have to that message. Ms. Monroe complains of the natural and ordinary meaning. That is not the same as a literal meaning. The literal meaning, that Ms. Monroe had herself scrawled on and vandalized a memorial, would be rejected by the reasonable reader, having regard to the context. The reader would see the tweet as having an element of metaphor. But it is, to my mind, an inescapable conclusion that the ordinary reasonable reader of the first tweet would understand it to mean that Ms. Monroe condoned and approved of scrawling on war memorials, vandalizing monuments commemorating those who fought for her freedom. That is a meaning that emerges clearly enough, making full allowance for everything that seems to me relevant by way of context, the characteristics of Ms. Hopkins and Ms. Monroe, the nature of Twitter, and the immediately surrounding contextual material on Twitter. The reference to grandma would not be understood, but that would not affect the reader's conclusion. These conclusions about meaning are not substantially affected by the further matters relied on by the defense, which I regard as, and shall refer to, as the innuendo facts. The vast majority of those who read the first tweet will have seen it on Ms. Hopkins' homepage, where it was the first item for the 2 hours and more that it was up. I would not accept that all these readers will have been aware that 9 days earlier, on the 9th of May, the war memorial had been vandalized, that Penny Red had posted her controversial tweet, and Ms. Hopkins had posted her condemnation of it. Ms. Hopkins' homepage had 10 times as many views each month as she had followers. The extent of the overlap is not disclosed by the evidence. It is not likely to be 100%. The press coverage of the 10th of May was mainly in the liberal press. I can infer, on the basis of general knowledge, that there is not likely to be much of an overlap between readers of the Independent and Daily Star and those who follow Ms. Hopkins or read her homepage. I would accept, however, that many readers of Ms. Hopkins' homepage will have been aware of the innuendo facts. It is likely that there are many who are regular readers. But it does not follow, and I do not accept, that the hypothetical reasonable reader of Ms. Hopkins' homepage, with that knowledge, would have taken away from the first tweet a meaning very different from its natural and ordinary meaning. The innuendo meaning, to the reasonable reader, would be that Ms. Monroe condoned and approved of the fact that in the course of an anti-government protest there had been vandalization by obscene graffiti of the Women's War Memorial in Whitehall, a monument to those who fought for her freedom. This is a more specific and targeted version of the natural and ordinary meaning. The same meaning will have been conveyed to any others who read the first tweet, and knew the further things relied on by the defense. The innuendo meaning is not one of which Ms. Monroe complains, though it is not very different. I note that the natural and ordinary meaning I have found is not in the end very different from the meaning for which Ms. Hopkins herself contends. The main difference is the word politically, which does not seem to me to add much, but is a rhetorical flourish that is not part of the meaning in my view. Read in isolation, the second tweet will have conveyed Ms. Hopkins' contempt for Ms. Monroe, and suggested to the reader that she was poisonous, worse than the irritating at Penny Red. But there is no complaint of any natural and ordinary meaning. The claim is based entirely on an innuendo. The argument is that a proportion of those who read the second tweet will have read it in the context of the innuendo facts. The particulars of claim also refer to and rely by way of innuendo on the fact that the first tweet had been published only shortly beforehand. I accept these points. As to the first tweet, it had been deleted before the second tweet was posted, but I find that happened only very shortly beforehand. I find that the reasonable reader, knowing these innuendo facts, would have understood the second tweet to mean that Ms. Monroe condoned and approved of the fact that in the course of an anti-government protest there had been vandalization by obscene graffiti of the Women's War Memorial in Whitehall, a monument to those who fought for her freedom. In other words, it bore the same innuendo meaning as the first tweet. The reader with knowledge of the facts relied on will have understood Ms. Hopkins to be acknowledging that when she sent the first tweet she had mixed up Ms. Monroe and Ms. Penny. But the reader will have taken what Mr. Bennett rightly calls the defiant second tweet to be asserting that this mistake made no difference. Ms. Monroe was portrayed as even worse than Ms. Penny. By implication, the suggestion was that Ms. Monroe also approved of and condoned the vandalism, and shared the views which Ms. Hopkins had so clearly deplored. Did the tweet's meanings have a defamatory tendency? There is no doubt about how Ms. Hopkins regards those who vandalize war memorials, and those who condone such behavior. She has made that clear. But her case is that it is not actionable to suggest that someone condones such behavior, because such a suggestion is not defamatory as a matter of law. She is entitled to say, and Mr. Price is right to submit on her behalf, that a statement about a person's views is only defamatory if it attributes views that would lower a person in the estimation of right-thinking people generally. This old phrase is of course about people who think correctly, and it refers to common standards. It also covers left-thinking people, and those in the middle. In a diverse society, there are many with views of which some people approve and some disapprove. The demands of pluralism in a democratic society make it important to allow room for differing views to be expressed, without fear of paying damages for defamation. Hence, a statement is not defamatory if it would only tend to have an adverse effect on the attitudes to the claimant of a certain section of society. The classic example, though far from this case, is a statement that someone is a grass who informs on criminals. That is not defamatory because informing on criminals is generally considered to be a good thing to do. The judge's task is not to impose his or her own views. It can be put this way: to determine whether the behavior or views that the offending statement attributes to a claimant are contrary to common, shared values of our society. This again is a matter for judgment, not a matter for opinion polls or other evidence. It can be difficult. But one test is whether the conduct or view in question is illegal or, by the standards of society as a whole, immoral. In Thornton, Tugendhat J. set out an ordering of the varieties of defamation. His summary of personal defamation included, at 33.2a, imputations as to what would perhaps now be expressed as what is illegal, or unethical or immoral, or socially harmful. Mr. Price relies on this principle, submitting that no doubt those on the right of the political spectrum may be more or less appalled by such a sentiment, but that is not sufficient to make it defamatory to allege that someone is aligned with it. The submission is correct, as far as it goes, but rather misses the point. The criminal law can generally be taken as an expression of society's shared values. As a rule, right-thinking members of society generally deplore those who commit offenses. They also disapprove of those who condone criminality. As Mr. Bennett points out, spraying graffiti on public monuments is a criminal offense. It is also socially harmful. Generally, I accept Mr. Bennett's submission that right-thinking members of society generally would regard this as obnoxious behavior, and would strongly disapprove of anyone who approved or condoned it. There may be exceptions to these general points. But in this case, the suggestion was condemnation of the vandalization of a war memorial commemorating important roles played in World War II. Respect for those who gave their lives, or put themselves in danger, or played roles in the world wars is a significant aspect of the shared values of our society. Here, the vandalism was carried out to express a political view. But it has not been suggested that this would justify it in the eyes of right-thinking people generally. Nor do I believe it would. There was no apparent link between the political cause and the monument that was attacked. The vandalism was carried out in peacetime, following a properly conducted general election. I have no doubt that the natural and ordinary meaning conveyed by the first tweet and the innuendo meaning conveyed by the second tweet were defamatory by the standards of the common law. It is submitted for Ms. Hopkins that the first tweet was only directly published to a small number of individuals because it was an at-reply tweet. It is true that it only went to the timelines of those who followed both Ms. Hopkins and Ms. Monroe. 1 It is common ground that this is a small group, the defense estimate being 140. This is unsurprising, given Ms. Monroe's contrasting politics. But the first tweet was available to view on Ms. Hopkins' homepage for a period which I find was approximately 2 hours and 25 minutes. In addition, it will have been retweeted to the followers of other Twitter users. It turns out that by deleting the first tweet, at Ms. Monroe's request, Ms. Hopkins made the Twitter analytics unavailable. There is no criticism of her for that. But it means that the number of publishes via her homepage can only be estimated. The case for Ms. Monroe is that this can be done as follows. First, by appropriate division of the 5.7 meters profile visits to Ms. Hopkins' homepage in May 2015, with a view to working out how many of those visits are likely to have been made during the period on the 18th of May, when the first tweet was up on the page. That approach has obvious limitations but, in principle, would seem to be sound. It helps that Ms. Hopkins did not tweet again until the second tweet, so any visitor to the home page will have seen the first tweet as the top item. Secondly, Mr. Bennett refers to the Twitter analytics for other tweets sent by Ms. Hopkins on 17 to 18 May, submitting that these provide a reliable guide. The figures relied on are for impressions, engagements and retweets of all tweets posted by Ms. Hopkins between 2048 on the 17th of May and 2147 on the 18th of May 2015, other than the first tweet. Again, this seems to be a source of evidence from which appropriate inferences can be drawn. Relying on these two approaches, Mr. Bennett invites me to find that the first tweet had something in the region of 20 to 25,000 readers via the @KT Hopkins homepage. Mr. Price submits that the claimant's estimates are no better than guesses, with no solid basis. He argues that any substantial traffic to his client's homepage in the 2.5 hours at issue is likely to have been from followers of Ms. Monroe and followers of Ms. Penny, drawn by the offending tweet. He submits, and I accept, that there were few who followed both Ms. Penny and Ms. Hopkins. Further, says Mr. Price, it would be wrong to assume that every impression amounts to a viewing of a tweet. The claimant's case, he submits, is at the very top of the range of conjecture. He argues that it would not be safe to put any figure on the readership, and that Ms. Monroe has not satisfied the burden of proof. Alternatively, he invites me to find there was some relatively small publication in the high hundreds or just into 4 figures, made up mostly of followers of Ms. Monroe and Ms. Penny. The evidence has convinced me that Ms. Monroe was very upset by the first and second tweets. This is apparent from her angry reaction to the first tweet. Some of what she tweeted afterwards to her own followers could be read as making light of what had been said, and as mocking Ms. Hopkins and reveling in the prospect of suing her. But the case for the defense, that this was the true overall picture, is not made out. People can react in a variety of ways when wounded. This individual, in this situation, wrote some things that turned out to be unhelpful to her case in this action. But they were written in the heat of the moment. Generally speaking, I accept Ms. Monroe's evidence about how things were for her that evening. Her initial reaction was to be completely horrified, both that people would think that I had vandalized a war memorial, and at the incoming storm that would be heading my way from the many people I believed would accept that what the defendant had said was true. Ms. Monroe thought the accusation was being targeted at her personally. Believing Ms. Hopkins had a massive following on Twitter, she anticipated that she would start to receive abuse as a result. Ms. Monroe's evidence is that she received abusive tweets from people who had read those complained of. I shall come back to the evidence about the torrent of abuse, which is hotly disputed. But I accept her evidence that she felt anxious and upset, and had difficulty sleeping. I also accept the claimant's evidence about her reaction to the second tweet, and her feelings at the way that Ms. Hopkins has behaved since publication, and how she has conducted the defense of the proceedings. Ms. Monroe found it very upsetting and frustrating that rather than say the first tweet had been false and express some regret about posting it, she just switched her line of attack and made what Ms. Monroe saw as a deliberate call to arms. There has been no apology, and I accept that this has allowed the claimant's injured feelings to remain raw. It is said that Ms. Hopkins acted maliciously in sending the second tweet, knowing it was untrue to suggest that Ms. Monroe had vandalized or condoned the vandalization of a war memorial. I do not know what Ms. Hopkins' actual state of mind was, as she has not given evidence, nor has she explained her position otherwise than through her lawyers. If she had done so, and persuasively rebutted what Ms. Monroe says about these matters, I might have disregarded this part of the claimant's evidence. But in the absence of any rebuttal, I conclude that Ms. Monroe's response was and remains a reasonable one. All of this, however, is about injury to feelings, and the issue I have to address at this stage is whether serious harm to reputation has been proved. Where an allegation has a seriously defamatory tendency and is widely published, a claimant may choose to rely on those facts alone, perhaps in conjunction with evidence as to the identity of the publishees, as the basis for an inference that serious harm was actually caused. That, at one stage at least, was the primary position adopted on behalf of Ms. Monroe. In some cases it may be enough. It is certainly not necessary in every case to engage in a detailed forensic examination of the precise factual picture, in order to determine whether the serious harm requirement is satisfied. Often, the factors relevant whether serious harm has been caused will be the same as those which come into play when assessing whether a tort is real and substantial. In this case, however, the issues on serious harm have developed, and the evidence and argument has spawned a reasonably complex set of interlocking or overlapping sub-issues. This is mainly due to the way that the case for Ms. Hopkins has been pleaded and pursued. There are no less than 11 main issues. I have reached the clear conclusion that the serious harm requirement is satisfied, on the straightforward basis that the tweets complained of have a tendency to cause harm to this claimant's reputation in the eyes of third parties, of a kind that would be serious for her. In the light of that conclusion, I do not believe it is necessary for present purposes to examine in exhaustive detail all the sub-issues. Nor do I think it necessary for the purposes of arriving at a fair and reasonable conclusion on the extent of harm, and the appropriate sum in damages. I therefore do not think that I do an injustice to the considerable skill and effort that has been devoted to these issues if I identify and address them in turn, in fairly summary form. The main points, and my conclusions on them, are these. 1. The extent of publication. Reliance is placed on the allegedly limited extent of publication of the first tweet, and its deletion around 2 hours after first publication. I have dealt with and rejected Ms. Hopkins' case on these points. 2. Transience. It is true that the first tweet was transient. The second tweet less so, although any tweet disappears from the reader's view as time goes on. But this is a weak point. What matters, when considering transience, is not the period of time for which a person is exposed to the message but the impact the message has. It is a commonplace of experience that live broadcasts can have a powerful impact, even if the viewer sees them once only. Print copies of newspapers are not often read more than once. A person who proves they have been libeled is entitled to recover a sum in damages that is enough to compensate for the wrong suffered. Other factors that can affect the appropriate amount include, 1. Whether or not the defendant has persisted in maintaining the truth of what was said. 2. The fact that a reasoned award may help to vindicate a reputation. 3. The status of the claimant. Public figures such as politicians are expected to be more robust than others, whatever the actual position may be. There is an overall ceiling on awards in this field, currently about £300,000, Raj v. Polawazia, 2015, EWHC 382, QB, 179, HHJ Parks QC. That sort of award is only suitable for the gravest of libels such as widespread publication of allegations of genocide, terrorism, or murder. There is no tariff of libel awards. The court must seek to reflect the particular features of an individual case by placing it in its proper position on the scale that leads up to this maximum. Regard can be had to awards for personal injury, and there are decisions on particular facts to which the court can have regard, but there is nothing that really assists in this case. In this case, the allegations were serious but certainly not towards the top end of the scale. The extent of publication was significant but not massive in its scale. The harm to reputation, though serious, will not have been grave. The need for vindication is not a weighty factor, as there has been no attempt to prove the truth of what was alleged. This judgment will make the position clear to those who were unaware of it already. Ms. Monroe is a public figure, in the sense that she chooses to engage in public life and to engage in political discourse in public forums. The injury to feelings was real and substantial, and has continued. It has been significantly exacerbated by the way the defense has been conducted. Nonetheless, compensation for hurt feelings should be in scale with the award that seeks to compensate for harm to reputation. Taking account of all these matters, my award is £24,000. That is divided into £16,000 for the first tweet and £8,000 for the second tweet. The reason for this division is that the majority of the harm to reputation will have been caused by the first tweet, and it was that tweet that caused the greatest injury to feelings at the time. These awards are higher than they would have been if damages had been assessed at or shortly after the time of publication, because they take account of the fact that the harm to reputation has continued, and injury to feelings has been increased by the defendant's behavior. The first tweet was a mistake. It was not fully retracted, but there has been no attempt to prove the truth of what was suggested. Ms. Hopkins will realize, and no doubt be advised, that to repeat the same message would be likely to result in a substantial damages award. I do not consider that there is any evidence of a threat or risk of repetition. There is no need for an injunction.